Hi, I'm Gerald Arrington. I'm an attorney at Black Blanket Associates, and I represent clients who are facing DUI charges. If you're watching this video, you may be dealing with, or you just may have general questions about DUIs here in Colorado. Today, my goal is to guide you through the DUI laws in Colorado and talk about what happens if you're charged with a DUI or related charge and what options are available to you.
What is the difference between DUI and DWAI in Colorado?
In Colorado, DUI, driving under the influence, means that the state believes that a person was substantially incapable of driving a vehicle safely because of alcohol, drugs, or both. If your blood alcohol content is a 0.08 or higher, the law presumes that you're under the influence. A DWAI, however, is a lesser charge, and that stands for driving while ability impaired. And it applies when the alcohol affects your ability to drive even to the slightest degree. This often involves a BAC or blood alcohol content of 0.05 to a 0.079, but it's not based on a strict number alone. The key difference is the level of impairment that the state is claiming, and that difference matters when it comes to penalties.
How does marijuana factor into DUI cases?
So Colorado treats driving under the influence of drugs, what we often refer to as DUID, the same way that it treats alcohol-related DUIs. So if a blood test shows 5 nanograms or more of active THC in your blood, the state's allowed to infer that you're impaired. It's important to understand that even if your blood has less than 5 nanograms, you can still be charged with DUID if the officer believes that there is other evidence of impairment present. Marijuana DUI cases are highly fact-specific, and they're often much more complicated than what people believe.
Will I lose my license immediately if I get a DUI?
Possibly, depending on what happens after the arrest. So if you refuse a blood or a breath test, Colorado law allows for an automatic license revocation. You then have 7 days from the date of arrest to request a DMV hearing. If you miss that deadline, your license is going to be revoked automatically. A blood alcohol content of a 0.08 or higher can also trigger a revocation. And if you're ultimately convicted of a DUI, your license will be revoked. The DMV process is separate from the criminal case, and it moves very quickly, which is why timing matters.
What are the potential penalties for a first offense DUI?
For a first offense misdemeanor DUI in Colorado, the penalties can include jail time ranging from 5 days to 1 year in jail, although jail may be suspended if you complete court-ordered education and treatment. If your blood alcohol content was a 0.20 or higher, the law requires that you serve at least 10 days in jail. Fines typically range from $600 to $1,000, and your license may be suspended for 9 months, though early reinstatement with an ignition interlock device may be possible. You'll also be ordered to complete community service and mandatory alcohol or drug education classes and treatment.
What are the potential penalties for a first offense DWAI?
Well, a first offense DWAI carries lighter penalties, but it's still very serious. Jail time can range from 2 days to 180 days, though it may be suspended with education and treatment. Fines typically range from $200 to $500. Unlike a DUI, a DWAI does not automatically revoke or suspend your license, but it does add 8 points to your driving record. Community service and education classes will also be revoked.
What if I have a prior DUI or DWAI?
Penalties increase significantly with prior offenses. The second offense means 10 days to possibly 1 year in jail, higher fines, and more community service. Third offense carries a mandatory jail sentence of 60 days, and a fourth offense becomes a felony, and that includes potential prison time and parole. Repeat DUI cases are actually treated much harsher in Colorado.
What kinds of defenses are there for DUI cases?
Every DUI case begins with a traffic stop. Police must have a lawful reason to pull you over, such as speeding or an obvious equipment violation. They may even make vague claims like poor driving that can be challenged. Next, we look to see whether the officer had probable cause to arrest you. Field sobriety tests can play an important role in that, and it's important to know that these tests are not mandatory in Colorado, and there is no penalty for politely refusing those. They can be administered incorrectly and are often designed in a way that makes them difficult to perform, even for someone who's sober.
What about breath and blood tests?
So Colorado's express consent law means that by driving, you have already agreed to take a chemical test of your blood or your breath if you're arrested for DUI. Refusing that test results in an automatic license revocation, and that refusal can actually be used as evidence against you in court. That said, chemical tests are not immune from challenge. Issues with calibration, contamination, or testing procedures can all affect its reliability. In some cases, a rising blood alcohol defense may apply, meaning that your blood alcohol content was lower when you were driving than when it was when the test was administered later.
Can you get a DUI on a scooter or an e-bike?
Surprisingly, yes. Colorado's DUI laws apply to vehicles, which can actually include bicycles and other non-motorized vehicles.
What would you tell someone who is facing a possible DUI charge?
A DUI charge is very serious, but a charge doesn't mean you're guilty yet. Colorado's DUI laws are complicated, and the consequences can be very significant. Getting clear information and experienced guidance early can make a very real difference in the outcome of your case. If you're facing something serious, you don't have to handle it alone. We're here to explain your options, protect your rights, and help you move forward.